Court of Appeals, Division 1 is now in session.
Please be seated. This is the time set for oral argument in case CV150009, Maricopa County Attorney's Office versus the Maricopa County Employee Merit System Commission and Mark Smith. Counsel, let me advise you that you both have 20 minutes to present your arguments. The proceedings are being recorded, so please keep in mind that within a few days of this argument, it may be uploaded to YouTube, I believe, actually. So you're being recorded, and it's audio and video recording. If you will, when you step to the podium, please announce so we know your name and we have your name correct and who you represent. We have reviewed all the briefs and the record in these cases, so we're very familiar with the facts. And, of course, I'll advise you again of this at the end of the proceeding, but we will issue a written decision following oral argument today. If you want to set aside any time for rebuttal, counsel for appellant, then please state so when you get up at the podium. You may proceed.
Good morning, Your Honors. May it please the Court, my name is Tawn Thornton. I represent the Maricopa County Attorney's Office, which is the appellant and the employer in this case, and is referred in the briefs for short as the MCAO. I wish to reserve 3 minutes for rebuttal.
How much?
3 minutes.
Yes.
Thank you. We are here because the Merit Commission overstepped its bounds. It substituted its own judgment as to the appropriateness of dismissal of a law enforcement employee who left his fully loaded county-issued gun in the restroom of a convenience store.
Ms. Thornton, I apologize. We have so many questions we want to ask, and so I just wanted to get started with that. I didn't mean to be rude. I guess the first question I have is the decision about Lieutenant Copeland and Mr. Smith being similarly situated employees. I can see from the record that the hearing officer addressed that issue and the commission later looked at it. Was that an affirmative defense that Mr. Smith brought up, Detective Smith brought up for the first time before the hearing officer, or had the appointing authority, had your client made any findings or considered that issue before it went to the hearing officer?
The appointing authority has to consider whether the employee is being treated consistently with similarly situated employees.
But there's nothing in the letter of discipline, the termination letter, that states that.
Correct.
I just want to be clear where I'm going with this. Obviously, there is a far more deferential standard in looking at findings or determinations or considerations that were made by the appointing authority before it goes in front of the commission versus those that are brand new, de novo, in front of the commission. And so I'm trying to get a sense of when this issue came up and whether your client can make the claim. We did make a decision on this. We did consider this beforehand, and so what they're doing is reviewing our consideration of that issue. Can you speak to that?
Well, as I said, the appointing authority has to review that. Now, if there are no similarly situated employees, which is the position of the county attorney's office here, then there's nothing required procedurally to note that in the letter of dismissal. And so there is an obligation to look at consistency, and that's a defense under the Juarez case to raise as far as its evidence of arbitrariness, but it's not a we frankly don't deal in terms of technically of affirmative defenses in a merit commission appeals. However, it's something that's raised in a hearing. That's where it's supposed to be raised. Now, it's supposed to be considered, but it's raised at the hearing, like Mr.
I'm sorry, Ms. Thornton, are you saying that it's an affirmative defense that's raised before the commission? Is that essentially what that is, the comparison employee cases?
I think that it's analogous to it, but it's
Okay.
and it's something that
Is that what happened here?
It really isn't evidence of, it goes to evidence of arbitrariness. I mean, in the Juarez case, the court said that arbitrary can be found in circumstances where similarly situated employees are treated differently, receive less severe discipline. And so there was none of that in this case, but Mr. Smith claims that there was. And so he brought forward evidence of that. Now, there's also a procedural obligation to provide copies of records of any similarly situated or arguably similar employees going back a couple of years. And so there's some procedural there, but there's not a standard that's set by the statute or in the
Let me explain
rules.
to you. Let me explain to you the dilemma that I'm facing in terms of your appeal. And I'm not saying that this is conclusive of where I am right now, but this is the dilemma, and maybe you can tell me why it shouldn't be a dilemma for me. If in fact this is an affirmative defense that's raised by Mr. Smith after the termination decision, he raises it before the hearing officer, and so the hearing officer actually determines that they're not similarly situated. But as I understand the law, the hearing officer's findings are advisory only. The commission can decide to reject or modify that finding. And so the commission then looks at this issue that's not an issue that's reviewing from the termination decision, but in its role as making the record, decides, well, they are similarly situated. They make that. And if that's a factual finding from which they conclude because they're similarly situated and they receive different discipline, we therefore can conclude that the termination was arbitrary. Doesn't that put us in a spot as the Court of Appeals? We have to be deferential to their finding that they were similarly situated, and therefore we have such a deferential standard of review. It really makes it difficult for us to go in and say, well, that's just arbitrary and unreasonable that you found they're similarly situated. Do you understand the dilemma that I'm...
Sure.
So how do you
Sure.
address that?
The commission failed to give deference to the weight the appointing authority had the discretion to give for the differentiating factors between the alleged comparators. So Mark Fall, the appointing authority, he looks at Mr. Smith's prior discipline and finds it to be significant. He finds that he had serious misconduct investigated in 2006 for somewhat similar conduct, misuse of government property. He is demoted and receives a final written warning. He decides to give that significant weight. And he also differentiates the comparators on the basis that the difference in conduct is more egregious, that Mr. Smith put the public at greater risk, and that the restrooms at issue here are different. Now, the commission is to look at that objectively, and if objectively that's a reasonable conclusion the appointing authority reached, it's reasonable that he would give that weight to the prior discipline, and it's reasonable that he would consider those bathrooms to be different based on his experience, based on the interests of the agency.
But I think that's where we get back to Judge Gould's original question, whereas he did clearly preserve his views about the prior discipline, and I think you've raised a very valid point about the deference that needed to be paid to that, and I have a question mark about whether that occurred. Because he didn't say anything about having looked at these two allegedly comparable cases, I'm not sure that the deference argument flows to that as easily, but that gets to an overarching question I have, which is I have real issues with the Merit System Commission's quote-unquote findings because I don't know what their findings are. The transcript is very confusing, and the order they issued just says that we adopt the hearing officer's findings, fact, and conclusions, except those findings and conclusions are supplemented by the appellant's objections to hearing officer's findings of fact, conclusions of law, and recommendation. A, I don't know what that means, but B, it seems from reading the transcript they believed that leaving a gun anywhere is a similarly situated circumstance. So I guess if he left it in the grade school restroom, they would view that as similarly situated as Detective Copeland. But isn't it inherent in their determination that prior discipline doesn't matter? Because they're saying they were similarly situated, and they never articulate why the prior discipline doesn't matter. And I have some real problems with that, because I think that gets to the deference issue. But aren't those two arguably different conclusions or findings? Leaving the gun anywhere is the same, but then prior discipline doesn't matter?
Yes, I mean, I agree with you. It's confusing, and based on the transcript, which I think this court can consider, I think that the Merit Commission was trying to fit into the order to comply technically with the wording, try to get there to the whereas, but what they really wanted to do was substitute their judgment.
Repeatedly persuaded them to do that, because otherwise the comments prior to that were all over the Juarez stuff you're not supposed to do.
Right, correct. And so it's a bit messy. We have we keep in mind that the conclusions of law recommended by the hearing officer 3, 4, and 5 were adopted without exception, because there were no objections to those conclusions by the Merit Commission. And the Merit Commission also accepted the findings of the significant serious misconduct in the past. Going back to the question about affirmative defense, there is nothing in the statute or the rules, the Merit rules, requiring the appointing authority to reach a finding that there are no similarly situated employees.
I understand that,
Yeah.
and I can completely understand why you wouldn't do that, because why? Well, I mean, you might, but inherent in a decision like that, I'm not sure every appointing authority would say, no, before we make this termination decision, go out and see if we have any similarly situated employees. I understand that. It's procedurally the way it came up in terms of, there's language in Juarez that talks about the commission, its primary role is to make the record. And so it makes the record. It can appoint a hearing officer to go in and conduct a hearing and compile evidence, and it makes a record. And it seems like maybe there's some tension there between the deference that the commission has to pay to the findings regarding the conduct, the facts of why the appointing authority terminated somebody or took certain discipline, and the commission's fact-finding role. You understand?
Right,
I mean,
right.
it's a little bit, and then you take footnote 6, I think it is, in Juarez, where the Supreme Court says, and yes, if they're not similarly situated employees, if they receive disparate treatment, that can be a grounds for arbitrariness. That footnote goes on to say the commission can, even if they decide that the discipline is so disproportionate to the conduct, they can find that to be arbitrary. So there's some confusion for me in that Juarez is sort of doing away with the old shocks the conscience standard, but there's a lot of language in there that still allows them some discretion in reviewing the appointing authority's decision. What do you say about that? Am I reading Juarez wrong, or is there a different way to read it?
I do not think that there's a lot of discretion there. I think that it left it that it's got to be an objective review, and there's a deferential role. And if there's reasonable cause, which is shown by preponderance of the evidence, which is on the appointing authority, that's the burden to show that the acts charged were committed, which is not an issue in this case. But then the second is just the arbitrariness. Was the discipline imposed arbitrary? And when you look at whether it was within the range of discipline, was it, did the employee have notice? I mean, here Mr. Smith knew he was going to face serious discipline. He guessed he probably was going to get suspended.
Are you arguing that the finding by the commission that these employees, Lieutenant Copeland and Detective Smith, were similarly situated employees, are you arguing that that is just an arbitrary finding? There's no way they could have reached that conclusion? It was unreasonable for them, the commission, to reach that conclusion based on the evidence?
Our argument is that it was an abuse of discretion to not give deference to the distinction, the differences that the appointing authority,
Okay, and that's
the weight that he gave. Oh, I see what you're saying.
That's where I'm having the trouble with your argument is what would they be deferring to? Because the appointing authority didn't make a finding on that before they terminated the employee. So why are they deferring to that?
They're not deferring to the egregiousness of the conduct that he concluded warranted dismissal. He concluded dismissal was warranted because of the egregiousness of the conduct, because of the prior discipline. Those factors, despite those factors, they conclude the comparators are the same. That is arbitrary because they're just not comparators.
But there's part of what we're talking about here is there's no finding, and nor would we expect one in the notice of dismissal regarding the comparators. So I think I hear you, correct me if I'm wrong, I think I hear you arguing that the commission should defer to the appointing authority's explanation in the hearing before the ALJ regarding the comparators.
Right. Correct.
Even though there was no written finding as we would normally have it prior to that.
Thank you. Thank you.
That's what you're saying?
Yes, you put it much better. But if you look at the
Don't
findings.
Don't compliment him too much. It's not a good thing for us.
Don't pay attention to him too much.
You have the findings that they adopted as supplemented by Mr. Smith's counsel. And those findings they're not in conflict too much with, there was more like supplement of also note this evidence. Also note that as a detective, he wasn't disciplined.
Excuse me for interrupting, but let me ask a question or two before we run out of time here.
Sure.
Are there any factual issues here?
No.
Aren't all the facts known?
That's correct.
They're essentially, the basic facts are undisputed, aren't they?
That's right.
We know what Detective Smith did. We know what the other two people did with their guns, and I'm not aware of any big factual dispute.
That's correct.
You mentioned, and I gathered that you thought it was important, but I wanted to understand better why, conclusions of law 3, 4, and 5. What was your point there, please?
So conclusions 3, 4, and 5 are that Mark Smith violated Merit Resolution 15 for neglect of duty, misuse of government property, and failure to fulfill its duty to protect county property. And
part of your point is those have not been displaced by what the commission did?
Correct. They were not displaced at all. There was no objection by Mr. Smith to those conclusions, and therefore they stand without any modification. And those
are they sufficient to support the original decision? Is that your?
That's correct.
Is that your point?
Yes.
Well, but still, if there was an arbitrariness to the original decision based on an improper comparison of similarly situated employees, then it's still arbitrary, isn't it?
Those conclusions show that there was grounds for discipline that includes dismissal. That's what. So now what they've concluded is dismissal is within the range of discipline available to the appointing authority to impose. That's cause. That's grounds for
counsel
for cause.
Nobody's really contesting that.
The commission affirmed those findings and affirmed the appointing authority's decision that the conduct or misconduct had occurred and that it was within the appropriate, or it was within the range of discipline. Right. They affirmed that.
Right.
They, at least at the end of the hearing before the commission, the decision to reverse is framed differently. It's the similarly situated employees. But I have a question for you. In the commission's decision to affirm the findings of the hearing officer, and then I guess also incorporate by reference the objections to those findings, can you speak to finding 6 by the hearing officer? Finding 6 is that the two employees were not similarly situated. So what the commission has done is they've affirmed that finding that they're not similarly situated, but then they've also affirmed the objection that they are similarly situated. Is what you're arguing that those findings are so inherently conflicting that it's it's an unreasonable or arbitrary decision, you can't affirm finding 6 and then also incorporate the objection?
Right.
You're
That's-
talking about conclusion 6.
Conclusion 6.
Conclusion
okay.
6, right, and conclusion 7. I mean, but
Is
conclusion.
that one of your arguments?
The objection is conclusion 6 and 7. Those two objections are what were supplemented in their decision, their order, right? So let's put it this way. There's two parts to this. First, the Merit Commission failed to defer to the appointing authority on what he had the discretion to decide, to give weight to. Second, though, there's substantial evidence in the record that conclusions 6 and 7 are not supported. And it was an error to have drawn those conclusions 6 and 7, given the evidence in the record, given the findings that were adopted, and the conclusions 3, 4, and 5. They are inconsistent with one another.
We didn't leave you your rebuttal time, but
That's okay. Anything else right now?
No.
Okay.
Thank you.
Thank you.
Good morning, Your Honors. I'm Caroline Pilch. I represent Mark Smith, who's the employee and appellee in this case. With me at counsel's table is Michael Pang. He's an associate in our office. In this case, the employer alleged not that the loss of the gun alone justified termination. The employer alleged that it was prior misconduct, that being the disciplinary history that reflects significant major performance concerns that the employer considered to decide that discipline of termination was appropriate. Therefore, the first question for the Merit Commission was whether, in fact, under the guidelines set forth by Juarez, because Juarez does not absolutely say that if conduct occurred, you must defer to the appointing authority's decision. What it says is if there is conduct, you look at that in a narrow and deferential standard. You look at it from the objective evidence that is presented to you, and then you...
Excuse me for interrupting, but I'm not entirely clear what is meant by the objective review when that phrase is used in the Juarez case.
I think it means that you review the evidence that's before you, things that come in from either side that can lead to what the Juarez court then defines for us as either an arbitrary decision or a decision that lacks evidence, because those are the authority of the Merit Commission is to sustain the employee's appeal if it finds that the actions of the employer were either arbitrary, and the Juarez court defines that for us, or if there is a lack of evidence to support the charge. So the
But
commission...
let me quote this language from Juarez, because this gives me pause in terms of the argument you're making right now, and this is a quote from paragraph 17, that people may differ, however, bolsters the notion that discipline initially imposed within standards and policies set by the appointing authority should not be disturbed merely because a reviewing body sees it as disproportionate. And honestly, when I read the bulk of the transcript from the commission hearing, it comes across as loudly proclaiming we think this is unfair and disproportionate, and counsel for the commission makes Herculean efforts to kind of get them back on the Juarez track, but I can't read that transcript and come away comforted that the Juarez standard was adhered to.
Your Honor, in that case, I too also want to point to the footnote in Juarez that tells us exactly that arbitrariness can arise, for example, when similarly situated employees receive differing sanctions for the same offense. Moreover, on an admittedly rare occasion, punishment can be so unreasonably disproportionate to the offense as to be arbitrary and without reasonable cause.
It gives rise to some conflict. But what did the commission here find? Because, as I said, I have great problems with this order sustaining appeal, because on the one hand it says we adopt the hearing officer's findings of fact and conclusions of law. but then it says, except they're supplemented by the objections. So we find all the things a hearing officer find, and then we also find whatever these objections are that aren't specified, which are inherently in conflict.
I don't think that that's the way that it is meant to be read.
That's what it says.
I think my reading of it is they accept the hearing officer's findings of fact and conclusions of law because those, to the extent they were not objected to, everybody agreed to. Smith filed an objection. The county attorney didn't file any objections to any of those findings or conclusions. So they accept those.
They adopt them, actually.
I'm sorry, yeah, they adopt them. Except
But they are supplemented. They don't say, and I understand where you're going, and that's kind of how I was trying to read it, but they don't say except those that we find otherwise based on appellant's objections. They say they're supplemented by appellant's objections, and supplementation is added to. So
and I understand what you're saying there. I think our position is when they said except that those findings and conclusions are supplemented means that
Modified?
yes, exactly, to the extent that Smith presented ones in his objection, the ones in the hearing officer's report are not.
Is it your understanding that the commission found similarly situated across the board? So we are saying leaving the guns in the places is similarly situated, and these people are similarly situated in disciplinary history too?
No, and that's exactly my point, Your Honor, that I started with. Because in this case, the employer alleged that discipline of termination was appropriate because there was an aggravating factor. And in fact, the actual letter that was provided to Mark Smith for termination, and I'm going to quote it, Chief Deputy Fall wrote, "When considered with your significant prior disciplinary history that reflects major performance concerns, I have determined that the termination of employment is the only appropriate remedy for which there is just cause to impose." That is what the employer said was the basis for the termination. That means that the Merit Commission must judge the evidence that the employer has to show whether or not there is prior significant prior disciplinary history that reflects major performance concerns. And that is what the commission looked at. They looked at, as you'll see, even in the hearing officer's report, but also as provided in Mr. Smith's objections, Mr. Smith had nothing but stellar performance reviews throughout his entire career. And in 2006, he received discipline for actions he did as a supervisor, and then he was demoted. But there's no question in this record, the objective evidence is that every single performance review from every single supervisor rated him as either distinguished or exceptional, just above what you can do. That's his performance. The commission then had the objective evidence to find that the employer did not prove, and again, under the words of Juarez as to what they must prove, they did not prove that there was reasonable cause. There was a lack of evidence sufficiently strong to justify a reasonable person in the belief that the act of significant prior discipline that reflects major performance concerns, as charged, was true. So once they made that finding, now we are just looking at the conduct of leaving the gun in the QT bathroom, and that is where the similarly situated come in. And that is another finding that was made. That was a finding that was made by the Merit Commission based upon the evidence that was presented. In this case, both Smith and Copeland left their holstered firearms in seat cover holders in a publicly accessible bathroom stall.
Let me stop you for a second, counsel. It seems maybe there's a little bit apples and oranges here. You're discussing that the commission reviewed the appointing authorities' finding that, in addition to the misconduct, Mr. Smith, Detective Smith, had a significant disciplinary history. Now, on that issue, I think Juarez instructs us that the commission really had to defer a heavily deferential standard. If there was just credible evidence to support that basis for termination, then the commission had to defer to the appointing authority, MCAO. So, I mean, you know, that if that standard were in front of me, and I knew that I had to, it was a credible evidence standard, and they had made that finding, that's about as deferential as it gets. Then you have a second aspect of the discipline, which comes up in front of the commission, and that is in the context of Copeland and Smith are the same. They're similarly situated. And that's the basis for them reversing MCAO, is that they said, no, these are similarly situated employees. They received disparate discipline. That's arbitrary. That's why they reversed it. It's clear that's why they reversed it. So, you know, the finding that it was an aggravating factor as a basis for termination, and then in the context of similarly situated employees, it seems to me those are really, they're taken in totally different lights in terms of how the commission has reviewed it. But let me ask you another question. How can one employee who has been disciplined on at least 2 occasions be considered similarly situated with an employee who has no prior discipline? How can that finding be made?
It is the employer in this case who said, Your Honor, they did not say and they did not tell Mark Smith that his problem was prior discipline. Their words, and I quote them again, are based on your significant disciplinary history that reflects major performance concerns. The actual evidence presented, including the 2 letters of reprimand, or the letter of reprimand and dismissal, do not speak to performance, and there was simply no credible evidence that there was a significant history of major performance concerns. Every single performance evaluation, which under the merit rules must be considered when someone's being terminated, show that Mr. Smith was an exceptional employee in
performance.
performance.
Performance way too narrowly, and at best it seems this is an area where reasonable minds could differ, because I'm reading Deputy Fall's letter of termination, and he goes through in significant depth things that I think could be viewed as performance. During the period you received a written counseling for misusing your assigned county vehicle. He goes into that. You sprayed a coworker at close range with a keyboard cleaner, causing a burn. You received a final written warning for calling subordinate employees chicken shit. I mean, I think most people would consider those performance of his duty issues. And so at best, reasonable minds could differ, meaning the commission had to defer to the appointing authority on that issue, didn't it?
Again, I respectfully do disagree with you, Your Honor, because of the position of the employer that Mr. Smith's disciplinary history reflected major performance concerns, and even reading the actual letters that were written to him, they don't reflect a major performance.
But that's where reasonable minds could differ, because those sound kind of major to me.
And again, I just respectfully disagree, but I do understand your point. I definitely do. But I think in this case, the commission was judging this case under the Juarez standard and looking to see if there was reasonable cause for the aggravating charge, the factor of aggravating charge, in order to justify the termination. And with that, they found that there was just simply a lack of evidence.
Are there any factual issues here? Are there any facts that are really in dispute?
No, I would have to say that I don't think there are any facts in dispute.
We're dealing with the assessment of those facts.
Right. Yeah, I would have to say that's true, Your Honor. In this case, getting back to the comparators for just a moment, in this case, the Merit Commission did make a finding that the comparators were the same. They did. And let me explain why. In this case, the evidence showed that Lieutenant Copeland left her gun in a public restroom in the Maricopa County Attorney's Office building. Only 6 months before, the very same person who terminated Mark Smith for leaving his gun at a QT
Counsel,
issued...
I understand the arguments on the weapons, and again, you know, people may disagree about that, but how about the issue of similarly situated where one has a disciplinary history and another has no disciplinary history? How is that explained?
Again, I have to go back to what I believe the Merit Commission did, and what I believe they did was look first to see if the Maricopa County Attorney's Office had presented credible evidence that there actually was significant disciplinary history.
That affected, I understand the language and how you read that in terms of performance, but setting that aside, okay, so you make a finding that there isn't a disciplinary history that reflects major performance concerns, that he can do his job well. But there is discipline. I mean, whether it constitutes significant performance concerns, there is discipline. How do you distinguish those two?
In that case, then, I go straight back to what the Maricopa County Attorney's Office policy actually reads and what happened between Lieutenant Copeland and Mark Smith, because they both were Maricopa County Attorney Office employees, and they both left their firearms somewhere unsecured. Now, in this case, the actual policy, the MCAO policy number 5.2A7, is very short and simple. It doesn't distinguish between location where you left that gun. It just simply says if you leave the gun unattended. Copeland left her gun unattended. In fact, the finding of fact, even from the hearing officer, relates that. She left her gun in the bathroom, and it was found by someone else, and it was returned. Now, the policy simply says, do not leave firearms unsecured, unattended at any time in a location accessible to any other person. When Chief Deputy Fall reviewed the actions of Lieutenant Copeland, he found that that was a very significant, dangerous action that she took. In fact, he, give me just a minute, I'll find what he wrote. The letter of reprimand to Lieutenant Copeland doesn't cite location. It specifically says, your failure to keep constant possession and security of your assigned weapon while in a public area is unacceptable. You exposed everyone in this building as well as the public to the possibility of that weapon's use by an unauthorized person. That is exactly what he found the conduct of Lieutenant Copeland to be. Mark Smith did the same thing. The policy does not distinguish between location, nor could it. But in this case, Mr. Chief Deputy Fall actually did testify that where the location of the gun was found made a difference. And that, I think, is the very definition of arbitrary, because if the policy simply says don't leave your gun unattended where other people can get it, then to then try and decide discipline based on, well, you left it at the park versus you left it here, you left it here, you left it here, now we get right into arbitrary, and that's subjective.
It's arbitrary. Perhaps your argument is that it's arbitrary because the standard doesn't say anything about location.
It does not. The policy itself does not say anything about location.
Could I take us down a different road for just a second? We're trying to apply and understand Juarez and what it says about the Commission's standard of review. Would you summarize for us what you think our standard of review is on this appeal?
I do. I think if there is any evidence in the record to support the Merit Commission's order, then this court must defer to the Merit Commission's findings. That's what Judge McClendon said in the Superior Court, and I know that the Court of Appeals in Blake versus City of Phoenix, basically, and I'll quote it, the court may not intervene if there is any evidence to support the administrative decision and should not weigh the evidence in making that determination.
But is what I'm not perfectly clear on here is whether our deference is owed to the Merit Commission or to the appointing authority with a review by us of whether the Merit Commission gave proper deference to the appointing authority.
I think that you have to give deference to what the Merit Commission did. You have to judge what they did based upon the record and determine if there was any evidence to support their decision.
And is that what Juarez says?
I believe that is also what Juarez says, because Juarez says, Juarez specifically says that it is Rule 10.16 that applies. And it says, when it is determined from the evidence that some level of discipline is warranted, the Commission then reviews the action taken by the appointing authority, not in a broad context requiring that the severity of the discipline be measured against the seriousness of the offense, but in a narrow and deferential context under a Rule 10.16 analysis, whether the action viewed objectively was arbitrary or taken without reasonable cause. And then they went on to define arbitrary as one that is taken without consideration in disregard of facts and circumstances, or capriciously or without adequate determining principle, such as deciding levels of discipline based on the location where a weapon is left. Or the second one
There would be adequate or at least helpful determining principle if the standard had said something about location.
Correct, but it just don't leave it unattended.
Yeah. Which paragraphs were you reading from Juarez? I don't have my copy in front of me here. If you have it handy, I'll find it.
Actually, I'm so sorry, I don't.
No problem. I'll find it.
I have it typed up here.
I can find it easily.
I'm so sorry.
No problem.
And the other is, of course, Juarez defined without reasonable cause. The Merit Commission looks at this to see if there's reasonable cause, and without reasonable cause means that there is a lack of evidence sufficiently strong to justify a reasonable person in the belief that the acts charged are true. And again, that's where we believe the Merit Commission made its decision as to the prior discipline that showed major performance concerns.
All right, thank you, counsel.
Thank you very much, Your Honors.
Counsel? I think that's 29.5 seconds.
Got it.
That you have.
Thank you. I'll just address three very important things I think that came out. First of all, policy 5.2.8.7. The appointing authority testified that leaving in a weapon unattended under any circumstances is serious. The policy doesn't speak to location. However, it would be unreasonable to expect an employer to set forth in some sort of matrix what might be a higher policy violation more egregious than another. And Mr. Fall gave Copeland, who testified to this, a warning that another instance of serious misconduct like this will result in your dismissal. That is consistent with what happened with Mr. Smith. Number two, this transcript at page 21 of the hearing, Mr. Fall testified, and this is under the Index of Record 16, that he reviewed the prior early discipline and found it to be significant and very troubling. So he may have been unartful in describing it as performance issues, but the testimony in the record is that he considered the prior discipline to be very serious. Number three, the standard of review. If you look at the Juarez decision in the very beginning, the court says the Superior Court and the Superior Court gave deference to the Merit Commission's decision as to the standard of review, and that was in error. And that is why the Supreme Court reversed and issued an order to have the dismissal of Mr. Juarez reinstated. Thank you.
All right, thank you, counsel. We will issue a written decision in due course. Court's in recess.